Thank you very much. Listen, I'd like to open it up to questions, and I will ask I'll take three questions firstly. I'll ask the following three people if they could give their questions. When you stand up or when you're probably sitting down speaking into the microphone for the purposes of translation, if you could signal your name, your organizational affiliation, and who on the panel you would like to address your question to. So first up, if we could have Dmitry Berezhkov, followed by Vicky Bowman, and then followed by Monica Shuji, in that order, please.
Я первое хотел бы поддержать Джоан Карлинг в том, что на самом деле очень беспокоит тот вопрос, что во многих дискуссиях, в том числе в этом самом здании, когда речь идет о руководящих принципах, коренные народы представляются лишь одной из уязвимых групп, в то время как коренные народы являются правообладателями.
I think any of us are getting it on the translation.
Сейчас есть перевод?
I think it's all channels.
Да. Я хотел бы...
I would like to support Joan Carling. In many discussions, when we speak about the guiding principles, the indigenous people are represented by just one vulnerable group. I think that the indigenous peoples are partners, equal partners with companies and governments. We need to change the mentality of business and the government officials. We believe that when we discuss the guiding principles, we should take into account the provisions of the Declaration on the Rights of Indigenous Peoples. We should speak about the fundamental right to the prior informed consent. This should be the basis of any implementation mechanism regarding any decisions concerning the extracting projects. Sometimes this agreement is not sought, and sometimes there is a violent suppression instead of consent in Russia. We can speak about a community in Buryatia. A commercial company wants to take possession of the land, and there is a resistance. And
with great respect, if you could
общину запугивают похитили двух ее представителей и держат в заточении. Поэтому очень важно, чтобы и рабочая группа, и другие...
I think we should keep it in mind, and the UN mechanisms should keep it in mind, and it is of exceptional importance.
Очень важно, как мне кажется, было бы обеспечивать встречи коренных народов.
We should ensure that before such meetings, the indigenous peoples should get together and develop their common position. Thank you so much.
Vicky Bowman.
Thank you. Vicky Bowman from Rio Tinto. Thank you to the panel for some really interesting presentations. And I just want to reassure, in particular, Leonardo and Joan, that within our company on this whole question of stakeholders, we have someone called Bruce Harvey, who I'm sure Megan knows, who constantly corrects any sloppy language when referring to indigenous peoples as stakeholders, because he says, no, they are traditional owners, they are rights holders, and it is insulting to refer to them as stakeholders. So we regularly stand corrected and are seeking to move to a point where we don't make mistakes on that. What I wanted to describe is a situation that we faced about 15 years old in the Philippines, which I think raises a generic question about what you do when the decision-making procedures of an indigenous people are such that it's easy for a third party to sort of step in between the company and the people and say that they represent that people. And this was a situation that we had when exploring in Zamboanga Peninsula, where we were looking to develop, or at least we were looking to explore there, and the Columban fathers told us that the Subanum people there were opposed to our presence. This was not something that our geologists had found on the ground, but the Columban fathers were adamant about this. And there was an NGO campaign, our AGMs and so on, saying that this was the case, we should get out. And we used the services of an anthropologist who'd been working with these people for 30 years to understand what their decision-making structures were, which was basically a number of dispersed households and no leadership. So each household needed to make that decision, which would mean that those Columban fathers would have needed to go to all of those households to understand whether or not there was likely to be consent. And we left, or we came to the conclusion that we didn't believe the Columban fathers could say whether or not the community would give consent, but equally we couldn't say whether or not they would not. And our conclusion was it was too difficult as a result of the whole sort of whipping up of the issue. The security situation was declining, so we withdrew. These who didn't have AGMs then moved in and continued to mine. And in fact, the Columban fathers came back to us and said, couldn't we do something about the standards of those companies? To which we said, no, not really, we're no longer there. So it was a challenge for us to get to the point where we could even start to understand what consent was, because we had this third party standing in between ourselves and the indigenous peoples. And sometimes that third party can be a law firm, and sometimes it can be an NGO, sometimes it can be perhaps somebody representing a faction of that group. But it is a challenge, and I'm just sort of throwing it out as a for the response of anybody in the panel, if it's something they recognise and what advice they can give. Thank you.
Chuji, please.
Buenas tardes, mi nombre es Mónica Chuji, soy quichua de la Amazonía ecuatoriana de la CONFENIAE y quisiera hacerle una pregunta a la señora Andrade. Ante todo quisiera agradecer por la exposición tan honesta y sincera que ha hecho sobre la situación de su empresa en la intervención en el territorio wayú. Es una pena, la verdad, que no estén hermanos wayú o hermanas wayú aquí que puedan establecer un diálogo con usted, pero sí le agradecemos la forma como ha expuesto los problemas que tiene y cómo usted ha descrito la cultura wayú y los problemas que tienen para establecer contactos. Yo estoy segura que si estuviera aquí alguna hermana wayú o un hermano, también dibujarían de una forma distinta su propia cultura y obviamente dibujarían distinto la cultura de ustedes y vuestra intervención después de 30 años. También, como decía usted, en 30 años es una lástima que no hayan podido conocer totalmente a la cultura wayú y sus instituciones, obviamente, en todo el proceso de intervención. En ese sentido, y con el afán que ustedes tienen de buscar diálogos con otros sectores, me gustaría saber, a propósito de la aplicación de los principios rectores, ¿cómo están utilizando ustedes los principios rectores a la hora de respetar los derechos a la autodeterminación, los derechos territoriales y el derecho a la consulta libre, previa e informada y el proceso de participación, obviamente basándose en los estándares internacionales de derechos humanos y sobre todo en un aspecto muy delicado que es de conocimiento general en este desvío del río que tienen allí en la zona. Nos gustaría, por favor, conocer aquello. Muchas gracias.
I ask the panelists to respond. I think we'll just take two more questions, if I may. Could I have Mr. Amaru Tupaj, and with apologies if I'm mispronouncing, and then Natasha Lecellier as well, please.
Gracias. Yo soy indígena quechua de Bolivia. Quisiera decir que de las declaraciones que han hecho los panelistas se deduce que las empresas transnacionales y los pueblos indígenas son completamente entidades diferentes. No puede haber una coincidencia entre los negocios y derechos humanos. Derechos humanos y negocios, rentabilidad, ganancia, son incompatibles con los derechos humanos y la dignidad del hombre. Es lo que están diciendo ustedes. ¿Y qué es lo que falta? Lo que se necesita es, no existe, como acaban de decirlo, no existe un marco jurídico internacional, ni existe una definición de lo que es una empresa multinacional. Hay una definición del Centro de las Naciones Unidas para Corporaciones Transnacionales, pero no existe consenso entre gobiernos y empresas transnacionales. Y, señor Anaya, quiero decirle que usted sabe bien que las empresas transnacionales están ubicadas generalmente en los países occidentales, en Estados Unidos y Canadá. Cuando se instalan sus filiales en América Latina, buscamos en Bolivia, Argentina, las empresas transnacionales tienen su sede social en Estados Unidos y se supeditan a la jurisdicción del país. Y el Estado boliviano o el Estado argentino no puede hacer nada. Ni siquiera existe una definición de lo que es transnacional. Eso. En segundo lugar, ha habido en los años 2002-2005 se ha elaborado por mandato de la Comisión de Derechos Humanos los principios directrices. Son una declaración voluntaria, pero nadie se ha referido en esta conferencia qué es lo que ha pasado con ese documento. El grupo de trabajo, que era el presidente del grupo de trabajo, justamente era un profesor de Estados Unidos, presentó a la Comisión de Derechos Humanos y desapareció. Y lo que va a pasar, estoy seguro, con los principios rectores que están elaborando este grupo de trabajo, va a pasar lo mismo. No va a tener un carácter vinculante jurídico ni para estados ni para multinacionales y lo van a echar al canasto. Y que los pueblos indígenas estarán en la misma situación que antes. Entonces, no debemos engañarnos. Si este foro no establece un código de conducta vinculante, entonces no habrá respeto de los derechos humanos.
Thank you. If you leave it on that note of the binding code of conduct, we'll put that question specifically to the panel. And I'm so sorry to interrupt, sir, but we do, out of respect to the panelists, want to give them time to respond. Thank you. If you could perhaps take. This isn't a conversation between you and me, Mr. Parry. It has to be between the panelists and the audience. Last question to Natasha Lesellier, very succinctly, please, before we turn it to the panel. Thank you.
Yes, hello, Natasha Lesellier. I'm with L'Oreal Cosmetic Company. I almost apologize to ask my question because we've heard so many serious and see how complex the issue is. But I was wondering whether the members of the panel would have some words of advice for companies who are not in the oil or extractive or mining industry, who have less knowledge of this and who nevertheless in their risk assessment don't want to, by a blind spot, pass over the right of indigenous people. So would you have advice for companies such as myself or others who are not directly or don't have this sort of experience on what should we be looking for in our day-to-day operations? Thank you.
Thank you. That's quite a lot for the panel to get their teeth into. I'll start with James and I, and then if we work our way down through the panel, I think we'll only have time for one pass of questions. So if you could, in the remaining time, quickly give your reactions to those. Thank you.
I'll start with this last question. Yes, of course, the issues that we've been discussing have been such that we've primarily focused on extractive industries because these are the cases that arise most often among indigenous peoples when we're talking about human rights problems. But by the same token, of course, the human rights considerations apply to other kinds of business enterprises. And I think the place to start is in examining this for each company is in risk assessment and in looking at what the company's activities how the company's activities may affect indigenous peoples one way or another, and doing a risk assessment in connection with possible infringements or undermining of their human rights. And then secondly, seeing how, and I think this applies to all business enterprises, companies can do more than simply avoid violating human rights. How companies can actually work to promote through their activities in various ways indigenous people's own self-determination through their own decision-making processes, through partnerships or other arrangements. And I know that we have some examples of cosmetic companies doing just that or attempting to do just that. Now, I'm not here evaluating those initiatives, saying they're good or bad, but I know that those initiatives have been attempted. So risk assessment, but also how companies can partner with indigenous peoples to actually advance their rights, not just simply avoid harm. There's a question by, or comment by Vicky, I'm sorry I didn't get your last name, from Rio Tinto, about the difficulties often in identifying who are legitimately representing indigenous peoples and through what mechanisms. You know, I think it's interesting to see that indigenous peoples have the same problem with the outside world, trying to identify who out there, you know, from who speaks for the company, who speaks for the government, who makes the decision. I mean, it's a mess, right? And so I think there needs to be an awareness that indigenous peoples face very much the same problem. And the solution lies in each side being able to have the space to develop the mechanisms to adequately represent themselves to the other. It is true that indigenous peoples in many places may be organized in such a way that it could be in certain contexts difficult to engage in a negotiation over a large project affecting a large number of people or several communities or several families. But I think what indigenous peoples have to be given the opportunity to do is to form those representative mechanisms that allow them to engage in the kind of discussions that will make for legitimate decisions, that will make for real consent processes or adequate consent processes. And this can take time. From how you described Rio Tinto's engagement in this one case, I think Rio Tinto took the right decision. If the conditions aren't there, they're not there, and simply pull out. And I think companies need to be prepared to do that. Again, I'm not evaluating this particular situation. I don't know the details other than what I've just heard. But that I think needs to be understood, that in some cases it will just take time, and indigenous peoples need to have the space, the time, and the ability to make decisions for their own about their future, which includes about how they will represent themselves or be represented in various processes. And that can be frustrating for some, but I think that just needs to be understood. And if it is, then there is the opportunity or the possibility of adequate consent processes. La pregunta del señor Pari, bueno, es.
Well, the question raised by Mr. Parry was a very relevant one with regards to the binding nature of our guiding principles. I believe that we need to recognize that these principles are a starting point for us to open up a discussion that could be, to see where we can be compatible and how we can combine human rights and business activities. We must be pragmatic about this and look at the possibilities given within the system. And it is up to all of us to take the necessary steps within this framework in order to reach a situation where the human rights of indigenous peoples are recognized, as well as other affected peoples. I believe that we shouldn't look at having theoretically binding instruments. We can have a number of treaties that are binding, but we need to know how are they going to be implemented in practice. This is what we want to have reaffirmed in the instruments that are implemented. And this is the stage that we are at right now. How do we implement these guiding principles in the daily lives of indigenous peoples?
Mónica, muchas gracias por la pregunta.
Monica, thank you for your question. And I will answer you in Spanish. For us at Cerrejón, this has been a very long learning process over the last 30 years, and mistakes have been made, but we also believe that there have been some accomplishments made. The policy, the good neighborhood policy, has allowed us to have a healthy relationship with the Wayu communities as well as other indigenous communities within the area. These are very simple practices, but nowadays we have a series of very high standard practices in place. And I believe that we need to approach this in a much more holistic way. We believe that the main that the new guidelines are a guideline for best practices, and we want to apply these guiding principles and to apply due diligence to protect, respect, and remedy. These affect indigenous rights as well as other rights, workers' rights, amongst others. And we must focus on these within the implementation of these guidelines. Enterprises are used to having impact assessments in other areas, and the human rights aspect is a new one that will allow us to identify where there are risks and where there might be human rights impacts. And we carried out our first impact assessment with regards to human rights last year, and we have reevaluated our systems in accordance to this. We already have an office based on human rights and the principles that have been established by the UN framework, and we believe that this has led to a determining factor to have a better relationship with the communities. This allows us to see what are our impacts on human rights and to remedy them as quickly as possible. Now, with regards to respecting the specificities of the Wayu community, I believe that over the past few years we have taken some serious steps, and we have learned more about their customs. We have realized that there have not been major human rights violations, thankfully, but there has been a lack of communication due to a lack of understanding of their culture, and we have taken steps to remedy this. And now we are focusing more on this approach. Now, with regards to the consultation that we are carrying out on the rechanneling of the river, the first thing that I would like to say is that the project has currently been suspended. This announcement was made a few days ago that there will not be a deviation of the river for various reasons linked to markets. And so the procedure will not be carried out for the moment, but we are also very respectful of the legal procedure with regards to prior informed consent. So we are following the steps that need to be carried out by law, and we have decided not to carry it.
Respond to two points raised. One is on the Rio Tinto. I share the same views as Jim on that situation, on the issue of the third party. But just to add that it's clear that the consent process should come from the affected communities. There's no role of the third party in the decision-making process. So, I mean, that has to be validated directly and not through other means. So that's I think the way to gauge whether there is consent or no consent. On the other hand, if there are already in the initial data gathering on the views of the affected communities, if there are already different views, that means there is no consent. yet. That means there is no consent in terms of the decision-making process has not taken place yet. So it should be appreciated or accounted in that context. On the issue of the company's risk assessment on what should be the consideration, and I think this is a very good question, because in all my experiences in dealing with this, the best way is always go for direct engagement with indigenous peoples through their legitimate representatives. And in the conduct of risk assessment, it should be clear that it should be participatory, that they should be involved in the conduct of risk assessments, because risks will be evaluated from their perspective, from their point of view, and nobody else, especially in terms of accounting for the socio-cultural dimensions and possible impacts, as well as, of course, in addition to the impacts to their rights. And if indigenous communities become part of the process, and it's a good faith engagement, and they don't see any harm, I don't think there will be a problem to establish a genuine partnership. So at the outset, that should always be the attitude: engage. There's nothing to be scared of in talking and relating with indigenous peoples. And then, because this is not just a one-way thing that you consult and then you leave, what's needed is to also ensure that there is a mechanism of continuous engagement with the leaders, and also to provide provision for capacity building. For example, how will they understand the information that you're sharing, so that they can also judge what can be the risks and implications to them. And that is a critical point with regards to indigenous peoples, the need for them to be able to understand the information given to them. Thank you.
Megan and then Leo. I'm being chastised for my poor chairing and timekeeping, so if I could go to both of you. Thank you.
Microphone for the speaker, please.
Sorry. What I wanted to say has really been said by Jin on that last question, risk assessment and how you can do more. I again say what I said in my talk, and that is urge you to read his report, there's a copy that's provided here at the forum that has extracts from his report, and I think it's such a excellent resource, I think, that contains really fundamental principles that I think businesses will find really valuable in terms of determining what you can do more and how you do that. And certainly that's something that I'll be doing when I go back to Australia, is encouraging our Indigenous communities to read his report properly too, because I think it contains really important guidance, I think, around principles such as free, prior, and informed consent and other issues. And just on the Rio, is it Vicky or Nikki? Is it Vicky? Yeah. And that's the fraught question, right, of who speaks for whom. And Jim's already answered, I think, appropriately your question. But it's interesting to reflect on your question in the context of Australia, because I think sometimes domestic legislation, such as the native title legislative framework, actually facilitates the emergence of competing groups, which is what you meant, I think, by third parties, and that can be really difficult to negotiate, I think. But anyway, they were just two thoughts that I had.
I'd like to address two of the questions that were made, and most of them were already addressed by the panelists. La primera es con respecto.
The first is with regard to the concern raised by Quechua brother from Bolivia regarding transnational corporations. Well, there is legislation in the United States that allows for legal action to be taken against corporations who have caused violations in other countries. It is important to know that in our countries where the corporations come and invest and carry out projects, there are local companies who carry out these projects. And often these projects are transferred from a transnational corporation to another within the same local company. And so they can use the domestic legal framework to carry out legal action against them. Often we have resorted to this with good results.
What companies can do in looking forward to when there is no project related to oil mining or infrastructure, clearly try to identify what are the risks in the project in violating or affecting the rights of indigenous peoples, and how the project can benefit the indigenous peoples according to international law. Sometimes following only states' laws and policies leads to a situation where you don't want to be as a company. And so that would be my advice on that regard.
To ask questions. I'd like to give a final 2-minute high-level sort of reflection from Chief Wilton Littlechild before giving our thanks to the panel. So Chief Littlechild, I'm sorry to constrain your time, but if you could quickly give us your perspective. Thank you.
Yes, thank you very much, and good afternoon to all delegations. I just want to perhaps take one thought from each of the speakers. The Special Rapporteur is always very positive approach in terms of advancing indigenous rights. Thank you for that approach. There were mentioned from the corporate representative traditional justice systems and the need to ensure training at other areas of the corporation, which then was followed by the very in-depth Asian perspective, but a very important observation as well, that it's the gross violations of the collective rights that also have to be taken into consideration. And of course, Megan's observation on the lack of awareness of indigenous people's rights, both at the state level and at the corporate level. These all lead me to, in a way, be thankful about MRIP's next assignment, which is on the right of access to justice, because these seem to be all access to justice issues in a way, and that'll give us an opportunity and a forum to continue this very, very important discussion that you've made possible for us this afternoon. Thank you very much.
Thank you so much for those remarks. And tiny announcement, the discussion around indigenous and extractive issues will be continuing in a side event, which is taking place immediately after this in room 11. Other than that, my profound thanks to the panelists for excellent presentations and reactions. And Pavel, a final word to the UN Working Group as we leave the room, please. Pavel.
Yes, thank you very much. I'd like to be very short and brief. I will try. Firstly, I would wish to say that, of course, the history of relationship of indigenous people with business is very long and protected and unfortunately negative one. Many leaders of indigenous peoples in the whole world started their activity by fighting the projects of companies and corporations who came to their land and to their peoples. Therefore, this negative tendency and trend should be overcome. I would like also to say that the guiding principles are not such a fundamental document which would open up a new history of protecting rights, including indigenous people. The guiding principles is a part of the whole system of human rights, including the United Nations fundamental rights, as well as other documents of the World Bank, of the European Banks of Reconstruction and Development, and we should look at those guiding principles through this prism, and of course they open new possibilities for indigenous peoples. Well, firstly, the process of interaction with private business, with transnational companies. Well, they go beyond the charity business, charity issues. Yesterday we heard that. We talk today not about charity, but about rights. And this is a very important issue. Yesterday it was said also that this states are preoccupied today to maintain, to safeguard their sovereignties. But the sovereignties should not be used as a bouclier, as a cover to violate and transgress the rights of indigenous people. The third pillar, the access to justice. We should develop the extraterritorial aspect, and we know that the rights of indigenous peoples are very often violated. We heard that about that this morning, now and in the afternoon. Those people, the indigenous peoples should have access, should be given access to the fair justice, and the guiding principles open this opportunity. And the last thing that we'd like to point out, that at the last session of our working party, we took the decision that in the year 2013, our working group will prepare a report to the General Assembly of the United Nations, and it will be called the Indigenous People and Business. And I do hope that you will provide us support, my colleagues, and they did a huge amount of work. This is a Bible for me, well, their work. Thank you very much for the dialogue, for the discussion. We are not finishing today. We will continue in future, progressing and moving forward. Thank you very much.
Good job.